Hello, everyone, and welcome. This is our weekly webinar regarding estate planning subjects that you and we find of interest. Yes, we will bring this in under 30 minutes as we do every week. Thanks for your note. That reminds me to let you know that the chat stream is open. At the end of the session, I will take questions, and that's the way that you can submit them. I'm John Miller, founding attorney with Rock Solid Law. And we practice estate planning, of course. We close real estate, helping people with the American dream, and we represent entrepreneurial small business owners, helping them survive and thrive during this important time. Looks like just about everybody who signed up is with us, so we will get started. Each week we are taking on a different aspect of estate planning. And if you missed some of the previous weeks, never fear, you can go to our website, which is rocksolidlaw.com, and look for the videos page, and all of those are on there. Most of them we've kept around the 20-minute mark. This one may go just a titch beyond that because it's a little more in-depth subject that we're going to touch on today. I think that a living will is the worst named document in estate planning, and I cannot through research, find out why on earth a living will was named a living will. It is so often confused with a last will and testament, and it has nothing to do with a last will and testament. We discussed a last will in a previous session, so those of you that have been with us know what that is. I cannot tell you how many times that I have received a phone call that says, I need a living will. And having practiced 35 years, I know now what that really means is I need to talk to you about my estate planning. I probably need a last will and testament. I may need a living trust. And as part of that process, a living will be introduced. So first lesson today, if you leave with nothing else, a living will actually has nothing to do with the last will and testament, except that it is part of the estate plan typical package of documents. Also, many people I encounter call this document a do not resuscitate order. Although there is language to that effect in a well-drawn living will, this is not the same thing. A DNR, or do not resuscitate, can only be issued by a doctor, and we can talk about that in more depth if you want to in the future. The living will is governed in Florida, and I am a Florida attorney if anyone's watching from out of state, by our statutes 765, 301 through 309. So it's a statutory document. There is actually a very short form in the Florida statutes that can be used for the purpose, although we find that a better form is useful. In fact, we have two different forms that when we consult with our clients, we discuss and use the one that's better suited to your needs, basically a short form, and a long form. Important fact, a lot of people are curious. The statutes in Florida regarding a living will do not permit euthanasia or assisted suicide in our state. So what is a living will? A living will expresses the manner in which you wish to be treated during your final illness. It will express what forms of treatment you want to be withheld at what point in your life. So you've heard me call it regularly a ticket to ride. Little Beatles reference there, of course, but yes, it's our ticket to ride out of this life and into the next life. So it is a document that basically instructs the treating physicians what treatment to give and what treatment not to give you during that final illness. So many of you know that the final illness of our lives typically costs more than the medical treatment we've had throughout our entire lives. I've read literature that says the last 5 days of your medical treatment will be more expensive than the rest of your life together. So a lot of people are making the choice of whether they wish to be unnaturally prolonged. I jokingly refer to it as inheriting the hospital foundation, or whether they wish to have the life support removed, and so that their own last will and testament and or living trust come to effect, so that what they have earned during this lifetime is actually shared with those that they've chosen, whether it be their children or other heirs, whether it be a charity or just what. So I would like to go this morning briefly over the main parts of what we put in our living will. And let me say this, except for the very short amount of material that's in the statute, the rest of it is your personal choice, just as is our whole estate planning package. The choice is up to you whether to include most of the things that I'm going to talk about this morning. If you want to know exactly what's in the statute, we can talk about that another time. So I have a living will form that we use typically. Ours is a 6-page document, the last page of which is just for signatures and witnesses. It is required that there be 2 witnesses as part of this process. I highly recommend that if you are going to do a living will, you do it in the presence of an attorney or his team who knows what they're doing in estate planning, so that it is executed properly and with the formalities required by the statutes in Florida or whatever state you are in. All right, so the first thing is a living will is how you select to be treated in that last illness. And the first thing that you are saying is that you make it known that you desire that your dying not be artificially prolonged. And then you get to define what that artificially prolonged and what that dying means throughout the document. So first off, there are 3 choices. And does this become in effect when you have a terminal condition, an end-stage condition, and or a persistent vegetative state? So effectively, many people remember the Karen Quinlan situation, where she lived long-term in what is considered a vegetative state, in a coma, and was kept alive by artificial means, meaning the machines in the hospital that can keep our blood pumping, our lungs going, and other essential functions just to keep the physical part of the body alive. Those are all choices that you will make yourself. You may choose 1, 2, or all 3. In my 35-year practice history, I will tell you that the predominance of people will initial all 3 of those choices. And then those conditions that we just referenced must be confirmed by your treating physician, which is typically who your primary physician has referred you to, or an assigned doctor at the hospital, and another consulting physician. So it's not just one person that's going to decide, oh yeah, you're in that state. They have to have 2 of them consult together and agree. So that goes on, and I'm not going to read the whole thing because we don't have time for that, but this part's important. I direct that life-prolonging procedures be withheld or withdrawn when the application of the procedures would serve only to prolong artificially the process of dying, and that I be permitted to die naturally with only the administration of medication or the performance of medical procedures necessary to provide me with comfort, care, or alleviate pain. So there's an important point. By entering into a living will and directing your physicians, you are not going to have an unnaturally painful death. And that's a big deal to me and a lot of people I know. It excludes that. Another choice that can be made is to state that those life-prolonging procedures can be commenced until your family has a chance to visit you. We can consult on what that means. Often, however, if those are commenced, it is very difficult to get the people that have taken a Hippocratic oath to stop doing that once they are assisting you. Then there are a series of definitions. Who's the attending physician? What is an end-stage condition, right? So when does this become effective? When there's an irreversible condition that is caused by injury, disease, or illness, and to a reasonable degree of medical probability, treatment of the condition would be ineffective. So this is really talking about when you're in your final illness, you're not coming back. A lot of people use the term pull the plug. This says, take me off those machines that are keeping me alive at that point in time. Now, before I go on, out of all of estate planning, really, the living will is the most difficult document for most of us, right? That's why it's really important to talk this stuff over, perhaps with someone you love, and definitely with your lawyer, before you go in to finally sign it, so that it is perfectly crafted to reflect your values and your wishes on how you wish to be treated, that you're not just signing some form that somebody cranked out. There are a lot of really good living wills out there. The wishes are very well done. But my belief is that we're all individual and that we need to have an expression of exactly how we, how you, using the I, wish to be treated, okay? So way better to go over this stuff beforehand and not come and have to stare at the paper at the last minute. As I've developed my practice, I make sure that happens because I sat with too many people that it was just too hard for them at that moment to make these decisions about their death and these important decisions that are going to be how they're going to be treated in the final moments of their life. It defines what a life-prolonging procedure is, and that's a little bit technical, so I'm not going to go into it during this presentation. And then it has a long list of the type of medical interventions that you wish not to have go on when you're in this situation. Now, they are such things as ventilators and mechanical devices. Now, this is one we have to think about during the COVID period of time so that we have your wishes appropriately executed. Surgical procedures and blood transfusions. Move to intensive care. Most people at that point want to go in a place where they're comfortable. Maybe it's at a hospice, maybe it's at home. Have chemotherapy or radiation treatment. Here's the resuscitation, which causes confusion with the DNR. You need both if you want them. Active treatment of a newly discovered cancer, heart attack, or pneumonia. Artificial nutrition, that's food through tubes, and artificial hydration, which is water through tubes. So those are choices each person will make. Candidly, most people initial all of them. Some people wish to continue to have hydration during that final illness. So then they continue with the definitions for another page. And in my opinion, for the purposes of this webinar, the definition of terminal condition is probably the most important one. It is a condition caused by injury, disease, or illness from which there's no reasonable medical probability of recovery. Okay, so don't think that you go in to have a tooth pulled that the living will comes into place, right? It is that point in time where there is no reasonable medical probability of recovery. Excuse me. You then will set forth your intent regarding medical treatment when you're close to death, when you are likely to die. Your intent if you are in a coma and expected not to wake up or recover. Your intent if you have permanent and severe brain damage. Obviously not fun things to think about, folks, but we're all human and it's a possibility that any of us could end up there. What you're doing by executing this document is a beautiful thing for your family and those you love, because you're saying how you wish to be treated and not making them make those hard decisions for you that you didn't make for yourself. We then offer you the opportunity to have a number of other things addressed. Where do you want, what are your plans for a funeral or cremation or the disposition of your remains? Regarding your funeral or memorial service, we even have people specifically express what they'd like to have. I want to have a New Orleans style band. I had one fellow want to have a Viking funeral. I'm not sure how that works, but I think they're experts that can make that work out. Not sure we can do the flaming arrow in the boat over the ocean. I don't know if that's legal, but we'll check it out. How do you want to be? How comfortable do you want to be? It states, you can state that you do not wish to be in pain. You can state what would happen if there's depression or nausea. You can state you want a cool, moist cloth if you have a fever. That you want your lips kept moist and dry. That's me. If you know me, I'm the chapstick guy, right? It is whether you want to be bathed regularly, kept clean at all times, massaged with warm oils, have your favorite music played. And you know Mr. Rock Solid is going to have a playlist ready to go for that. It talks about personal care, like hair, nails, those sorts of things. Some people feel their best when that's done. What do you want to have done to you when you're in that point in time? And then there's a nice section on how you wish to be, for other people to treat me. Have people with you, not have people with you. Most people, literature has shown, are happier in the passage when they have people, and especially if possible, loved ones with them. Do you want your hand held? Do you want members of your faith community to be there? Do you want to be cared for with kindness and cheerfulness? Do you want pictures of your loved ones surrounding you at this time? Do you want the bedclothes and linens regularly changed? I'm going yes on that one. If possible, do you want to die at home? Some people do. Some people don't want to die in their home. And then there's a section on what you'd like your loved ones to know. You wish your family and friends to know you love them. Be forgiven for the times you have hurt other people, and let them know you forgive them. That you don't fear death, if that's true. And it's not an end, but a new beginning. For a lot of people, that is what is believed. Family members make peace with other before my death. I love that one. Some families can. That you want to be remembered before you, as the way you were before you were young, with your vitality. And that they need to respect your wishes, even if they don't agree with them. To consider this a time of personal growth for everyone, including me. And to suggest counseling if they're having trouble grieving for your death. Then we have the proper formalities for the signing of the instrument. And we can craft this to reflect any other needs or desires that you might have. I have heard of people calling this document a directive to physician. I kind of like that idea, and I've been thinking through the process of creating this webinar of perhaps retitling the instrument we have with the subtitle Living Will, since people are aware of that. Maybe it is a written declaration to physician regarding life-prolonging procedures. Those words describe what this document is and its purpose. It is telling your caregivers, your health caregivers, how you wish to be treated and when you wish to have those life-prolonging procedures withheld. I've called it a ticket to ride. It's truly our ticket out of this life and into the next, if there is a next. Can't answer that question for you on online today. So I'm going to open it up for questions. I see I have one already. I want to thank all of you for tuning in to the webinar this morning. I see I'm coming in just about on time, and would invite you, if you have specific questions, that are a little fact intensive and not appropriate for the open forum, to submit those to questions at Rock Solid Law, and we will be delighted to answer them. So the first question I have today is, what is that Florida statute section? It is, pen and paper, Florida statutes section 765.301 through 765.309. And I would suggest to you that it's pretty good drafting. I believe it's fairly easy to read. I know that, a long time ago I went to law school, and so I have a lawyer brain, and sometimes I think words that are normal are not ones that other people use commonly. But I believe that you should be able to read through that. And if that raises any questions, go to the questions at rocksolidlaw.com and let us know. Oh, you're very welcome. Thank you for stopping by. And I understand you have a 9:30. If you have any other questions, let me know, and please, you stay safe too. Thanks for that. Floor's open. Any other questions you'd like to ask before I begin to wrap up? I'll give you a minute. Again, I'd like to say that really, while it is one of the most difficult parts of the path to getting your estate plan in place, that it's a beautiful thing to do this direction or directive to physicians so that you say how you wish to be treated. Why is it beautiful? Well, one, you get what you want, and two, you tell the people that love you how you wish to be treated, so they don't have to make what could be an agonizing decision at a very difficult time, and they just follow your wishes. Yes, as a part of the process, the question is, what if I want to donate my body to science? As a part of the process, we have a different document that is an organ donor document, and we would have that as part of your package as well. I particularly appreciate that question because I actually have a family member who was the recipient of a donated heart, born as a baby with a malfunctioning heart, and only lived because someone else made the decision to donate. What a beautiful thing. This child is now 12 years old and is living a remarkable life. So I highly thank you for asking that question about donating your body to science. I highly encourage people who philosophically are inclined to do so to be organ donors in whatever capacity. I always like to say, whatever's left over, if anybody else can use it, they can have at it, because I'll be done and moved on to the next space. The next question is a statement. Hospitals usually ask if you have one of these. Yes, they do. We will instruct you when you do this process with us to give it to your general practitioner, your primary care physician, but also to create a folder. I always suggest a bright, maybe happy color, so that if you or your loved ones ever are having to go to the hospital, you grab the folder and take it, and it, by law, has to become a part of your file with that healthcare provider. So thank you. The healthcare provider should ask that question, and candidly, everybody should have one, because we are the species that's able to think these things through, and therefore we ought to, A, be treated the way we wish to be treated, and B, allow those that love us to not have to make this hard decision but rather just to follow our instructions. How long can you have this document before it expires? What a great question. It doesn't. So you may have been on the one where we talked about powers of attorney, and of course they expire at the time you die. If you have a living will, it will be in effect through the moment that you pass out of this life. So you would technically never have to create another one as long as you know where yours is, you've given it to the proper healthcare providers, and haven't changed your mind. Of course, if you changed your mind or there's new medical science that you've read about and you want to do something different, you could always revoke the previous and execute a new one, which is something we've helped people do over time. Although typically once people get their document, which is formally going to be known as a living will in my practice, in effect, they just leave them alone. I would suggest that if you do change it, you need to be sure to advise your general practitioner, your primary healthcare provider, to destroy the previous one. All right, I know I'm coming up on the half-hour mark. I appreciate you guys all being here, and I hope that I have answered all the questions you have. I've answered all the ones that I see on the chat box. I will again express my gratitude for your wanting to learn about this stuff. I do think that living will is the worst choice of name for any document in estate planning. And I believe that this ticket to ride out of this life should be called a written declaration to physician regarding life-prolonging procedures. And I believe that our practice is going to start doing that. I am not seeing any other questions at this moment. Oh, there are. How did those get up there? Where can we visit your recordings? Wow, thank you for that question. They are at www.rocksolidlaw.com, and I think the / is videos. I will type that into the chat box as I allow you to listen one more time to that wonderfully named song for 2020, Zoom by the Commodores.